All right, let's get to it. Thank you all for coming in. Once again, my apologies for not being able to open up Q&A session last Saturday, but thank you all for reaching out and giving most of your votes to our co-host here, Frenchie, who told me that today would be a good day and time for the most of you. Can you guys all hear me? Leave a thumbs up in the chat. Loud and clear, good to go. Cool. Thank you. All right. So I will be adding additional people coming in as we go through it, as always. This is going to be from 4, I got it from 4 to 6 p.m. Eastern Standard Time if we have to go that long. If not, then we will cut it short. Maybe we can get all of these questions in within an hour, maybe an hour and 15 minutes. It's all up to you. Once again, the rules are, if you ask a question, raise your hand, and I will call on anybody that's random. But I will keep note of who I spoke to, so I'm going to try to go through at least everybody at least once. Then once I've gone through everybody, if you have a second question, you may raise your hand if time permits. So before we get started with answering questions, I want to go over some information. Let me share my screen. We had some questions coming in on the website about the first thing that we do in this process, such as authentication of your documents, right? So let's kind of clarify some of those concerns. Let's share my screen here. You should all be able to see that. Now, I would highly recommend this company here, this website called Postiointcom. Some people are born out of the country of the US, they're born in Japan or Germany or whatever, and they have been naturalized. And so they have a certificate of naturalization here in the United States. And some of you want to get that document authenticated, which you can. I've always told you that you don't have to. You actually are pretty much done, but some people still want to do that. So you have that option. If you want to do that, you may contact this company and they will help you with it. They'll actually do the whole process for you because, as you know, let's say if I'm born in Japan, I got to contact my place of birth or whoever is holding my records in Japan and begin the process of authentication or apostille. I could actually go down the street to my Japanese consular of affairs and have them do it. Sometimes they do, sometimes they don't. A third option is to contact a company like this, and so that they will do that for you. Now, once again, you don't have to. If you have a certificate of naturalization, you can just take that certificate, place it into your trust, and be done with it. If you want to authenticate it, you can. This website is pretty cool, excuse me, because it will keep you up to date with the non-Hague Convention countries. So as you go down, you will see that our most famous two that I promote, Taiwan and Thailand, are still here, despite what travel.state.gov says, okay? A lot of times their own website is not going to be up to date with the correct information. We've talked about that in the past. So these are countries that you can use if you want to do authentication. Let's say you're born in the state of Nebraska, you need to start from the beginning and do this. You may use any of these companies or countries here. You can get about 10. If you go to your vital statistics, you can get about 10 birth certificates, and I advise that you authenticate as many of them as you can. Get all of them under your trust, get them under your belt, because that's going to play an important role when we start to talk about closing the CAFR accounts. I think everybody knows what that means. And you have to have your trust accounts ready for such a thing, okay? So you got to get all your birth certificates, as many as you can, get them authenticated and place them inside of the trust. And you do that via additional trustee minutes as you go along. Another thing, one of our co-hosts, administrators here, you guys know him by James, he pointed out an individual. He shared a link with us, and when I took the time to read it, it was about an individual who's in the NFL. And a lot of times, what we teach here, it's really a good sign to see that people out there in the celebrity world or high earning wealth earners are doing the very same information that you're learning here. So an NFL player by the name of Antonio Brown, he is doing the very same process, and he shares how it has affected his professional life. You can check out this guy. He's I think he came out of Miami. Right here it says Miami Norland High School, and he's played for about 4 NFL teams. Right now he's with the Tampa Bay Buccaneers. He's also the executive for the Albany Empire. Right, if we click on that, it's going to take you here. Albany Empire is a team within the National Arena League. It's like a smaller version of the National Football League. And if we go down, it's going to talk about his involvement, his ownership with this team. It says here in March 2023, former NFL wide receiver Antonio Brown joined the team as a part owner. Brown said on April 16 that he was the 100% owner of the team. Quata disagreed, stating that he and Brown each earned or owned 47.5%, with Steve and Charlotte Von Schiller owning the remaining 5%. Antonio Brown bought Quata's 47.5% stake for $1 on April 19th, increasing his stake to 95%. On May 3rd, 2023, Brown's representative told the Times-Union, a newspaper in Albany, that Brown has no personal ownership or control over the empire, and that the team is actually owned by Antonio L. Allah Express Trust Enterprise, which is owned by a foreign citizen named Antonio L. Allah. A letter addressed to a Times-Union reporter described Brown as not the owner of this team and also not a citizen of the United States at birth, which caused confusion. So, of course, the reporter at Times-Union, they have no idea what this being talked about, but you and I do, those that are learning this information. Antonio L. Allah Express Trust Enterprise is the fiduciary for Antonio L. Allah Express Trust. Remember, in your declaration of trust, in mine that I've shared with you, it was Avery Imago Dei Express Trust, doing business as Avery Imago Dei. So right here, when they list it as this is the shorter version of that full express trust name. And of course, it is a foreign citizen. Why? Because a foreign sole trustee is a part of the trust. The sole trustee. There is no additional trustees a part of the express trust. However, you can have an infinite amount of trustees connected to the trust enterprise. And so this enterprise is holding everything on behalf of Antonio Brown, so that way he has no personal stake. So I thought that was very, very cool to share, to show that there are people out there that are doing it. It's actually more common than you think. All right. Let me stop my share there. Now, we have about a couple hands up so far. And we have an unknown. I don't know who Zoom user is. So if you can, please try to list your name exactly as you have it in the course so I understand who you are. So I'm going to let that person change that. So I'm going to go to Samuelson. Samuelson, you are unmuted. How are you?
Hi, Avery. Can you hear me?
Loud and clear. Thank you.
Okay. I want to be quick, but I need to express gratitude for the wealth of knowledge you've been providing people through the outlets. I discovered you when I discovered the need for TCUs, and I haven't looked back. You cut away all the bad stuff I'd otherwise be trying to filter out. Thank you for everything you do.
That's my pleasure. Thank you.
Okay. I have one very quick question and then one that might take a little more thought. The first one is it's real simple. My LLC owns the house. My wife and I own the LLC. If I transfer the LLC to the trust, do I need a quitclaim deed if the LLC is going to continue owning the house?
It depends on your overall plans for the house. Do you want to keep it in the family forever, or do you plan on selling it?
My daughter told me she's never going to not have this house, so I don't think I'll ever sell it. I'd rather just leave her childhood house. It's
Okay.
a multifamily house. It could make money. There is a mortgage secured by my ens legis. That was the only hiccup.
Okay, no problem. No problem. Yeah, you can use your ens legis to acquire property. I mean, that's the easiest way to do it these days.
Yeah. The LLC owns it, so if I transfer the LLC, will I need a quitclaim deed?
I think any transfer is going to require some type of quitclaim. So, have you ever considered just quitclaiming over to a land trust and making your current LLC the trustee?
That's a thought. I'll look into that. Let me make a note.
Yeah, you could do that, or you can put it into the express trust itself, the foreign express trust, and then from there you can make your trust enterprise like a trust company. You can make your trust enterprise the trustee as well, and set up your daughter to be an additional passive trustee to the enterprise.
Well, she's got some time before she'll be old enough to have her own trust, but we'll get there.
Mm-hmm.
If the LLC is owned by the trust, doesn't the trust own the house anyway?
The LLC is, if the trust owns the LLC, is that what you mean, right?
Yeah, because I'm going to classify the LLC under the trust and restate the articles of organization as you've taught. And so when I finish that, my question was, do I need the deed because the LLC owns the house and the trust is going to be doing business as the LLC?
Correct. You still would need to do that conversion.
Got it.
Yep.
So as per your state injunction video, the subheading includes a specific law pertaining to civil authority sitting higher than the military. My state, New York, is the only one that has not included this language. All power appears to be vested in elected officials. Do you have any experience withstanding the New York State injunction on its constitution?
Good thing about all of the states in the union is they operate through full faith and credit. So if you find a state that has the favorable laws that you're looking for, you can bring it into New York. One of the easiest ways to do it is to find a case law supporting what you're talking about in either the state, or just grab from the archive departments one of those states' constitutions, place it inside of your trustee minutes, record that in the form of an affidavit within the local newspaper, and then therefore that newspaper can be recorded in your county within New York. Now it is considered full faith and credit. They must accept it.
Okay, so I can get full faith and credit before I even get the annexation number with the birth certificate, because that's with the state right now. So
Correct.
By publishing it and filing it, I don't need to wait for the annexation number, or should I still?
You don't have to wait for it, because I know a lot of times they are slow with that information.
Got
It's going to come to you at some point, and you're going to put it into the trust anyway.
Fair enough. Avery, thank you for your time.
Good questions. Thank you. No problem. Right, we're going to Melissa. You are muted.
Hello. So I was getting ready to go file a bill of complaint. I've done the whole process. It's with First Citizens Bank and Trust. It's under our company. The loan is under the company. Well, I was getting all this stuff ready, and I came across that there was a UCC filed by them already. and this was before we did any of our trust stuff, does that affect the accord and satisfaction?
If they have filed a UCC against you or against your business names, that's just a secure loan that they have with you. That's all. You can still.
Okay, so we can proceed. Okay.
Yeah.
Okay, I just wanted to be sure. I filed another one with Ford. I've done the whole accord and satisfaction with that, and they got served on this July 26th, and so it expires in a month. So, well, actually, it actually says the due date is 8/17. So if they don't respond or anything by then, what do I do? Because I haven't heard anything from them.
Yeah, if they don't respond, you can try to look up their arbitration department. And well, actually, it'll be a good idea right now to do that before it expires and try to send over everything that you filed in the court to their arbitration department. Because little known secret is every company has an arbitration, and that will serve as a court of equity, an opportunity to handle everything and to give you what you want without going on the court record.
Okay, because I served their registered agent in Missouri.
Good.
So then if they don't answer, I find their arbitration company.
Yeah, just go to their website and go to the bottom of it, and you'll see in their terms and conditions and privacy notices that they'll list their arbitration center.
Okay.
And forward all the information to them there. If that still doesn't work and you hear nothing, then you have the right to submit for a summary judgment.
Okay. A summary of re-judgment?
Summary judgment. That means
summary judgment. Okay.
that you placed inside of your what is that section? The demand for relief. You're asking everything to be granted to you because they failed to reply.
Okay. All right, perfect. Thank you.
You're welcome. Wish you the best with the case.
Thank you.
Going to Katie Hobbins. You are unmuted.
Hi, Avery. Hope you're well. Quick question. I have the 98 for the foreign trust. I haven't gotten any of the paperwork. I did get the I.R.S. paperwork, just confirming what the 98 was. At what point can I start using that to file UCC liens?
Your 9-8 will have nothing to do with the action of filing a UCC lien. That's
Okay.
just a number to let the federal government know that any entity that you're earning money with is going to be classified under that 9-8 number for tax purposes. Now, when
Okay.
you're going to do a UCC lien, the very first one is that non-UCC in your county. That's going to list your name as the debtor in almost every way that you're used to seeing your name: first, middle, last, first, middle. And then when you get down to the junior course, you'll see where I talked about the UCC 3. There's an update on how we do that initial non-UCC listed in that video. It's going to talk about listing the 3 or the 4 major express trusts that began this entire United States corporation from the beginning. And we want to list them as debtors on our non-UCC. This is the only way to completely sever the separation between church and state.
And that would be in the junior 2.0?
In the 2.0 junior course, yes.
Okay, the UCC 3. Okay. And then real quick too, is this going to be available for replay? Because there was some good stuff and I wasn't able to take good notes on it earlier when some other people were talking.
Oh, yes. After this is done, this will be uploaded within the site as well as YouTube.
Perfect. Thank you so much.
You're welcome. You're welcome. Okay, let's go to Jay Prater. You are muted. Jonathan, you there?
Okay, can you hear me?
Yes. Okay.
All right. I got two questions. One is with this 8832, and I've been seeing people in the chat was talking about it also. It's just something else because I got mine back, wife got hers back, it was all returned. Is there something else that we could send in with the 8832? Because what I'm thinking is there really isn't any information to show for the presence of the trust except for the 9-8. So I guess my question was, is there anything else that could be sent in with the estate? Because everybody's getting their estate returned just about from what I've been seeing.
Yeah, it's happened to me once or twice, my personal estate number. And I had to get another one because it's only good for 7 years. And I got a rejection on that too. So that's a good question to think about putting something else behind their 8832 to kind of give more support. I think the best thing to do, if you want to see if that can be done, is to look at the actual 8832 form itself on the instructions.
Okay.
And on the instructions page, see if they will allow you to do something like that, or if there's a special contact number or whatever. I know they have a contact number, but from my experience, because I have tried that, I have tried to add something from my Foreign Express Trust to show, look, this can be done. And that didn't help out either. So what I think would help, go on the back of the instructions, and there's a section that says, who must file? What I think you should do is highlight the type of entity that you are talking about and point that out to them and show that you can do this. There is no reason for rejection or denial. I think that's the best thing, because a lot of times the reps who are getting these things, they're not fully adept on all of the ins and outs of the process. They're just going off of what the computer does. So they scan these documents in, and believe it or not, there is a threshold on how many can be approved per month or per quarter, and how many can be rejected. Just like how many 9-8 numbers are going to be issued within a quarter. So it is a numbers game. You just have to keep playing the game.
Like the lottery, huh? All right, and the next one was with the process you just talked about, the second non-UCC along with the termination. I don't want to ask a stupid question, but I guess I am. We have to get another bond, don't we?
No, it depends on how long your first bond is for.
A year. That's the first one that we got for the Express Trust. Or can we still use that one?
You can.
Really? So I don't have to purchase another one?
No.
Okay. All right. So we just put the information on the third part of that UCC part. We just use the same information from the original bond.
Correct, because the principal in that bond is still pertaining to the same trust organization, right?
Yes, sir.
And that's perfectly fine.
Okay. All right, go with that. Me and my wife over here discussing stuff. We good. We got it. We just, because we've been in the video, we watched it a few times, and her thing was, well, you know how much the 200? That's the question. Does it have to be 250,000?
If you use that website that I gave, who's issuing, I think that is the max that you can that they give you. Any more than that, they're going to require more documentation or a phone call to figure out why do you need something that high. Okay.
And I forgot how much our first one was, but
yeah, if you want to go higher than that and you don't want to have that type of responsibility, then there's other companies out there that will issue you bonds for much higher with less scrutiny.
Okay. All right. But as of right now, the information from the first bond is good enough that I can continue then.
Correct. Yep. I've used the same one that's connected to my trustee for multiple recordings.
Okay. All right. Well, I'll send you an email when I get the price of how much it's gonna cost to do the mailing.
All right, no problem.
All right, I appreciate you. Thank you.
Thank you. Okay, who is Zoom user? I'm going to unmute. You are muted. Zoom user. Hand is up. Going once, going twice. All right, I'm going to put the hand down. And we're going to Jay Smith. You are unmuted.
Yes, sir. Hello, can you hear me okay?
Yes, I hear you.
Hey, Avery. I everything was okay over the other day. I was praying for you.
Yes, it was good. It's fine.
Good.
Thank you.
Yes, sir. I don't know how to phrase the question other than you're kind of aware of on one of our business entities and us personally, we have some issues going on. And so I was looking at, so we're still utilizing one of the business entities, and I think I'm going to dissolve it, but I was wanting to kind of see what your thoughts are with that. And if I did dissolve it, would I need to reclassify it and restate the articles before I do all that? I'm trying to move over to the enterprise, utilizing the enterprise trust instead of these entities that I'm having issues with, if that makes sense.
Makes sense.
Do you recommend that, or?
What I recommend is to first figure out of all these entities that dissolution is on the table about, can they all operate under one entity seamlessly for the business, or do they have to be separated?
No. So 90% of them were dissolved anyway. We were only using 3, and it's not like they're out in the public and have a brand name or anything. So we don't even care about the name so much. We're utilizing on 1099 contractor basis, but people really just kind of know us by our name, not the actual business entity name, if that makes sense. So it doesn't matter to us.
Mm-hmm. Okay. What you can do is take that name that everyone knows you by. You can operate as an unincorporated association and make that a DBA of the trust enterprise. So that way, the trust enterprise can have its bank account open, and all of the monies that is paid out to that new name, or that name that everybody knows of, can go directly into that bank account. That'll be a quick, easy way. Now, all the other companies that are existing, if you can dissolve them and it's not going to cause the company any hardship, yeah, dissolve it. Because if you can reduce all of the different filings and the record keepings, I would do so and keep it to 1 or 1 to 2.
So the my thought is, I have taken those entities and done the fictitious business name affidavit and published it to kind of get protected under that if anything arises in the future with this, and done the copyright. But then I got confused. Should I leave it open, or should I actually start dissolve at the state level? And it looks like there's a process to dissolve it with the I.R.S. as well. It puts the EIN in dormant status, it says.
I know for sure you can dissolve companies with the Secretary of State.
Yes.
And once that is done and all taxes are taken care of or reclassified under the trust, there's nothing further that you need to do with the federal government when it comes to the Foreign Express Trust. Remember, the Foreign Express Trust has a whole different playing field than everybody else.
Yes.
Right? So you're good there. if you've already submitted 8832s, if we've done that for you, that's fine. It will stay there. It just means to the federal government that those new EINs that have been classified are just not going to have any action.
Okay.
If there's no action, if over $600 in those entity EINs, it doesn't have to report.
Okay. We have not reclassify those with the 8832, so I guess I should probably do that, and then also restate the articles and then dissolve it. That's what I was.
No, just reclassify from
Okay.
the LLC to the Foreign Express Trust, and
Okay.
then go to the Secretary of State, dissolve them. You may have a little fee here and there depending on
Okay.
existing. Go ahead and close it out with it, be done with it, and you can contact Nancy or myself if you want to have help with establishing that unincorporated association, or just making a DBA for your existing trust enterprise. Let's say I have Avery Mago de Express Trust Enterprise, and I'm going to open up a church called Sunrise Baptist, right?
Yes, sir.
That's going to be the DBA of the trust enterprise. I can have an infinite amount of DBAs for the trust enterprise.
Yes.
Now that Sunrise Baptist, I'm going to get its own EIN number from the I.R.S. I'm going to list it as a 501. I'm sorry, what is that? You're basically 508c1a. That's going to be reclassified under the Foreign Express Trust. And I can now give that 508c1a EIN to anybody who's asking for evidence of my church, basically. But I don't have to make anything to give to the Secretary of State once I do that.
Okay.
That's the beauty of an unincorporated association. You don't have to give any documents to the Secretary of State. It's all private. If they ask for it, like let's say in court, I can produce it and it will be according to standards, but I don't have to record it because most secretaries of states, all I know is California and Wyoming off the top of my head that do have unincorporated association forms for you to file. But everybody else just wants a nonprofit association, which is not what we're trying to do here.
Okay.
Yeah.
Okay. So, and then also, so with that 508c1a unincorporated association, you would also need to do the enterprise trust DBA's publication in the newspaper as well.
Same path would apply. Yep.
Okay. Yeah. Okay. Thank you so much. And yeah, I might get with Nancy or you if you're available to iron out the unincorporated part.
Okay. We're here. She heard it, so she'll help you out with that if I can.
Yes, sir. Okay. Thank you so much.
All right. Thank you, Jay. So I hope that last question was understandable to you all. That's an important one. I think almost everybody in business will eventually need to know how to do. Let's go to Alexandra. You are unmuted.
Hi, how are you doing? Can you hear me?
Yes, I hear you. Yes, I hear you.
Okay. Thank you for taking my question and thank you for all the information that you share with us. I'm recently learning about all this and, getting into this, but I just have a question about, so say if I'm a real estate investor and I have a few partners that do not have trust and at the end of say we do a house flip, how would I go about, when we go to sell the house, how would I go about selling the house with my partners if they don't have trust and I do? If you can understand the question.
Yeah. No problem. I got feedback. You have to turn off your speaker.
Oh, okay. So I'm sorry. 1 second. Sorry. Hello.
Okay, there we go.
Okay.
All right. So if you are an investor in real estate and you have partners and you're looking to avoid taxation, but they're not really a part of this whole trusting, that's the question, right?
Right.
Okay. So there's going to be some capital gains here.
Right.
Are you guys doing this in the name of an entity, an LLC, corporation, S Corp, C Corp?
LLC.
Okay. How many partners?
Probably, well, so sometimes 2, but probably 3.
Okay. All you got to do is just update the articles where your name is. You're just going to remove yourself and put the trust enterprise there.
Okay.
So that way you can receive your portion of the capital gains directly to your trust enterprise.
Gotcha.
Now, your trust enterprise should have filed an 8832 reclassification form to put that under your foreign express trust.
Gotcha.
Okay. So once that is approved, then you can rest assured that whatever monies you get in the trust enterprise, it doesn't have to file on its behalf.
Okay, awesome. All right, thank you. Appreciate it.
You're welcome.
Thank you.
All right, we're going to Monica Marvel. You are unmuted. Oh, and whoever that was labeled as Zoom user, I believe that was Katrina. If you could raise your hand again, if you can hear, and I will call on you again. But for now, Monica, are you there? Just
Yes,
unmute
hi.
your mic.
Yes, hi, Avery.
Okay.
Thank you for having this platform and taking my question. I really appreciate all the valuable information you provide. Yes, I have a workers' compensation claim that's been going on for quite a while. And I won initially, but the other side appealed. And so I moved the appellate process to federal district court. And I was just wondering what might be my steps to, show that the express trust has, the rights, titles, and interests in the claim, as far as, maybe what type of documentation, what I need to file as exhibits, over there in district court to show that this is now, this claim in this case, this file number, this case number, so to speak, is in fact trust res and trust property of the express trust.
Okay, good question. Like any case, I have to ask, what is the nature of the complaint?
Saying that I have equitable interest, I was paying the insurance. I had a incident where I was out of work and displaced from work. And so my claim would be that the original award should be, upheld and not, I felt that they denied me, the reasons were frivolous. And I'm just basically coming in saying, hey, I have an equitable interest there, and that the insurance was paid out. I had been paying the premiums, and so just feel like it basically should be cut and dry. There was no factual documentation or any witness to rebut any thing that, any of the incidentals that led to them first, siding in my favor. So that would be my claim to say, I have equitable interest there. It should just be paid out. I have damages, that I'm able to prove, lost wages and such. And so that would be my claim.
Okay, I get the gist of it. If you want to prove that the trust is involved, because the actual plaintiff here is your full birth name, right?
Correct.
Okay. So what we do here, if you weren't in this case, in this claim, you still would do an affidavit of fictitious business name statement. This goes completely above and beyond the county forms that they give you, because there's limitations with that. And that also gives them control. So when we do it through an affidavit that's backed up by the trustee minutes, you have more power there. So what I would suggest is you go into the course, I believe that's the sophomore section or the junior section, and it's going to talk about putting together your affidavit of fictitious business name. There is where you're going to list all of the versions of names that your express trust is doing business under. Now, the good thing that you have an open case right now, you can actually record and complete your entire trust packet inside of this case because it's done down at the county courthouse. And the county courthouse has an actual immigrational officer within a naturalization court. That is your county clerk. And you want that person's seal to be on your documents. You can get that seal by just putting these documents together as the course shows and filing them into your case. That's going to show that the trust is doing business as your birth name, which is the plaintiff name. The DBA is the most important thing in this case. I wouldn't say that any other document that we show in this course is going to really be that necessary. You just want to show that you have equitable interest. That's it. And you don't want to be goofed around through the administrative procedures court process. So you're trying to stay within equity. You're trying to stay within chancery. Just showing them that the trust is doing business in your name and your name is on the docket as the plaintiff should be enough.
Yes, I've done that step already. So I do have those DBAs in place for the showing that the trust is doing business as those fictitious names. So would I request for that to be moved to chancery and for the case to be closed? I mean, in private chambers?
Good question.
I've been doing a little research.
Yes, I can tell. That depends. Now, you can only make a request like that if you can tell that the judge is being partial, if he's being impartial. If he is going outside of the Constitution and not giving you the proper remedy due, then you can request, look, I'm giving you the opportunity. Please move it over to the correct district or correct county where equity court is being held, because he's being partial. If you haven't gotten that far yet, leave it where it is. Just make your statement within your complaint that you want to be held and tried within an equitable court and leave it there.
Mm-hmm. Yeah, they're requesting for me to submit my pleadings. So that's kind of where I was a little stoked as far as, is this the time to, instead of doing a quote unquote pleading, just request for it to be closed in closed chambers because it is an equitable interest case, and then I'm claiming the, for it to be moved to chancery. Mm-hmm. Instead of doing the whole, like you said, the motions of, the court's administrative process, so to speak, when it's on the public side.
Right. Mm-hmm. Like I said before, your equity is pretty much arbitration. So you can search for your arbitration department within workers' comp in your state. And when they ask for your pleading, that's basically your bill of complaint that you've already put together. You just restate what you said in that complaint and send that over to the arbitration department, including the attorneys that's on the defendant's side and all of that. Every party has to get it. But when the arbitration gets it, I trust and believe me that you will receive a call to try and negotiate and come to a settlement outside of court. And that's what you want.
Absolutely. Thank you so much, Avery. I really appreciate you.
Thank you, Monica. Let us know how that goes. Please do.
I sure will. Thank
Okay.
you.
Right. Going to Cecilia. Cecilia V. Are you there?
Yes, I am here. Can you hear me?
Yes, I hear you. Thank you.
Okay, sir. I did an account satisfaction for a car for Ford before I joined your class, and then I sent a money order stating that is for a current satisfaction of all claims on the above amount. And they cashed it, and they told me that they received it. But they sent me a letter of the contract, and they told me that I did sign rights you and we agree to give up, like right to a trial, whether by a judge or jury, right to a class member in any class claim or any. It means that I cannot file anything against them, or right to appeal the decision of an arbitrator.
Mhm.
So my question is, with only one money order, without the bona fide dispute letter, do I have a chance to do a satisfaction of a court satisfaction?
I think you just answered your question. The last statement you said is you sent the money order without the bona fide dispute letter, correct?
Because I didn't know your process. Yeah, I did. I just sent the money order, and I did the administrative process, like,
Yeah. I've seen some cases. Frenchie and I have been searching, and we've seen some cases where people have won by sending a money order without a bona fide dispute, where the judge said it doesn't even matter. If you cash it, it's over. But there are a lot of cases that state that it is the state's rule. You must first send in that dispute. You got to find something within your loan or your contract that you disagree with. It could be the interest, it could be anything. You have to first send that there first before they start receiving those payments, so that way you can have a voice in arbitration or in court. So I would say let that money order be applied to the principal and interest, and start your bona fide dispute letter. Put that together, send that out to them. Also send to their arbitration department, and including their registered agent. Wait about 15 days, send another payment. It could be any amount you want. Recommend the minimum monthly payment or half, whatever you want to do. But send them something after that bona fide dispute is in their hands. And then I guarantee you, they won't send you a letter like that again. They may say we disagree with what you're writing in the dispute letter. That's fine. They may disagree, but at least they received a dispute from you. And that dispute is what's going to be in the face of the judge when you sue.
Okay. Even though I am in dishonor because I didn't continue paying because, yeah.
Right. You will continue paying until it's done, because when you win, you'll get all those payments back. That's what you're going to ask for.
Yeah, but I didn't pay, so I am behind the payments.
How many months are you behind?
4.
Okay. Sometimes you can contact the lender and do a rewrite to bring you current, or you can come current with those 4 months payments if you have it. But the main thing here, you want to stay in honor. You want to stay in honor at all times.
Okay, and sir, another question I have is that I've been sending the third-party debt collector to a medical collector,
Mm-hmm.
and they still reporting. This is like a third letter that I'm sending them, and they still reporting. What can I do if they keep reporting?
The third letter you sent them, now it's time to send a notice of intent to sue. You can easily find that type of document online. Do a notice of intent to sue. Now, this is how you scare them. Take your notice of intent to sue and publish it in the local newspaper. You have to tell on them. Let it be circulated in the paper. Once you have that circulated in the paper, send that publication to them directly, and they should take it off. If not, then you will go ahead and move forward with the lawsuit, and guess who's going to be your witness? The newspaper.
Perfect. All right, sir. Thank you so much.
You're welcome. At that point, you can even get a quick attorney, because they know all of the statutes and codes of all the monies that you can win from that. And you want to find the one that has experience with not charging you up front. They'll just take it off the grain from the wind. You'll walk away with money, and they'll walk away with a little bit. I think that's a good engagement.
Okay.
Yeah.
Perfect. Thank you so much for all the things that you have shown us.
My pleasure. Thank you. I thank all of you for being willing to listen and to take the chance and apply it to your own personal lives. This stuff is it's important to a lot of people, including the folks that I learned it from. And I enjoy seeing that it's still being used and worked professionally in many different industries. And people like you and I, we can do this. Very good. All right, we're going to go to Emperor. You are unmuted.
Thanks, Avery. So my question has to do with property taxes. So I did do a quit claim our house into the trust, but I haven't done the tax reassessment, because when I was listening to, I think your last Zoom, you had mentioned doing a nonprofit first, getting the letter from the state, and then submitting that. So I just wanted to kind of verify if it's a property that we plan on keeping, the best way to house the property, or if it is in trust, is it okay to go ahead and request the reassessment be done, or what's the best way to go about that?
Yeah, that's really the best way, is to start allowing the trust to utilize hired trust companies and 501c3 entities. What state are you in?
I'm in Texas.
Okay. I think it's the 1836 Republic Constitution that you pretty much will rely on. In there, I believe the tax section, you want to find out how they do it there for 501c3s and how they deem certain buildings to avoid taxation. If it's like Georgia or California, if whatever 501c3 is utilizing or doing things for the benefit of the public, scientific wise, literary purposes, religious purposes, or charitable purposes, if they're approved on the I.R.S. level and the Secretary of State level, then you will be able to have that tax exemption. So let's say you got a company that's 501c3 and it's been approved for literary purposes. That's the easiest way to do it. You're not going to be the president. No one in your family is going to be the president. You actually need to find a friend who's just listed as a president of that company, because that person cannot be connected to the Foreign Express Trust. Otherwise, there's a conflict of interest there. You're going to list that company as the trustee that's going to sign off on the actual quitclaim deed to the property. Okay. the letters that you receive from the Secretary of State and the I.R.S. is what's going to be given to the county assessor for them to understand that this property is going to be maintained by a literary or charitable entity. I select literary because what I do, I have the 501c3 act as a company to receive all of my trustee minutes and record them for the trust. So therefore, the trust is a member of that charitable or literary purpose or entity. That's a work that they do on behalf of the trust. Let's say we have someone who's questioning what we do. As long as you have the presidents, the secretary, the corporate officer of that entity not connected to the Foreign Express Trust in any way, you're perfectly in the clear. You're fine. Okay. That's how you want to do that.
Are you able to use if I already have like an unincorporated association set up, am I able to use structure that in a way to where I can use it for this purpose? Or would I need to set up a 501c3?
I would say set up the 501c3 because that's what they're familiar with looking at.
Okay.
For example, I tried that in California. I'm able to let the IRS know via my EIN application that this is a church, this is charity. I can select all of that. But when it comes to registering that information on the forms in California, they're not they have nothing on there for me to put 508c1a church as tax exempt in the same way a 501c3 would. There's nowhere on there where that is allowed. And so that's just an extra problem that you're going to run into. So just keep it to what they know, what they're looking for, to keep it easy. You don't want to have to promote some type of court date with the county assessor. I've been through that. It's not fun and it's a dead end. So I'm just trying to help you guys avoid certain things.
Perfect. Thank you.
No problem. All righty. Moving along. Going to Vicky O'Brien. You are unmuted.
Hello, Avery. I'm glad that this past weekend things weren't bad. I'm just glad everything's good.
Thank you.
Yeah, absolutely. So 2 quick questions for you. The first one is, and I'm asking on behalf of my husband who's doing this trust process along with me. Can or should you send in, if you're a W-2 employee, can you send in your new W-4 and W-8 VEN paperwork to your employer if you haven't received your completed 8832 form back from the I.R.S?
Yes, you can.
Okay.
Yes, you can. If you have your trust enterprise EIN,
yes.
And you got a bank account open, yeah, go ahead.
Yes. Okay, both of those are done. Perfect. That is what I wanted to know. The second question is in relation to accord and satisfaction. We have 2 different properties that we're working on our lake property right now, and we're getting close to doing the bill of dispute. That's the next step. But with our home property, what I'm noticing that's different is they did some things they should have done correctly in the mortgage. There are some things I can't catch them on, like I could on the lake property. So as I'm trying to put together this bona fide dispute for our home, I was curious if there were any other specific sections you were aware of under the National Bank Act of 1863 that mortgage lenders violate regularly that I should look into, that I could list for disputing.
I looked at those sections and I was really trying to go through it with a fine-tooth comb. I think the other section that you could mention is the one that's talking about the interest rates, how often they're able to change those, even when there's a refinance. I think they're breaking the law on that. Don't quote me on that. Just go back and read that. I think that's before Section 33.
Okay.
And, if you can, if it sounds right to you, let us know. I'll look at it again and I'll give you the okay on that.
Okay, the only other one, I'll definitely do that. The only other one that I looked at that I thought might possibly, and I wasn't sure if I was reading it correct, was section 46. It talks about usury for to forfeit the debt. And it looks as if it states interest can only be charged in the absence of a contract.
That's the one. Yeah, usury is interest. Yep.
Okay, and do you, I don't know, this may be asking, you may not remember, but am I reading that correctly? Because I looked over it a few times, and if that's the case, every mortgage is fraud because the mortgage is a contract.
Correct. Yeah, you're actually absolutely right. It's just section 33 is the one where I've seen more case laws focus on that.
Okay.
Disputes, yeah.
Okay, perfect. I was just looking for other things that I could use. I was going through it with a fine tooth comb to add to it because they did some other things. So thank you for that. And just if I could, I kind of wanted to add on to something somebody said earlier when they were talking about having an LLC and what to do with it. And just because I live in Texas, I had an LLC that I converted to a PMA in Texas. So if you're planning on keeping it, actually, if you go to the Secretary of State's website for Texas, it's pretty easy to do a conversion versus doing a dissolution and getting rid of it. It's actually a little cheaper and easier. You fill out a form, and the Secretary of State's office sent me a form back saying that the entity is not of record. I don't have to file. And I have that officially from the state. So just a little tidbit. It's a little easier to convert in Texas if you're going to keep it and do like an unincorporated association or PMA than it is to dissolve it. And it was fairly easy to do. I just had to send in articles of association with specific things stated in there, and I had no issue.
That's awesome. You see, you guys, someone's already doing it. There you go. I think that was Jay Smith. That was his question. Yep. Perfect. Thank you so much for that. Don't know if we lost Vicky, but thank you, Vicky. Thank you. So we're going to going to Ryan Fox. How you doing, Ryan? Can you hear me okay?
Can you hear me, Avery?
There we go. All right. It was kind of spotty, but we got you.
Can hear.
Yeah, go ahead.
My question has to do with a lease that I entered into. I'm not sure I structured things correctly, and I'm starting to have some issues right now. But I entered into a lease with the trust name as the tenant or the leaseor, and I did not use my enterprise. I just used the trust name. So my first question is, I'm wondering if what your opinion is on how I did that. Should I have used the enterprise or
using the enterprise for a lease for property? Is that the question? No, I think he dropped. No, he's still there. I think there's some bad signal on Ryan's end. I'll come back to you, Ryan. I'll come back to you in a few minutes. Let's go to Kim Wheeler. You are muted. Kim W. Going once, going twice. No, all right, we're gonna go over to, okay, you are here. Is your audio working? Says that you are still muted. Just have to unmute yourself. All right, I'll come back to you as well. Yeah, I'll come right back to you. Let's go to Kareem. Kareem, just gotta unmute your mic if you're there.
Hey, Avery. First, I want to thank you for all this information and everything that you and your team do, and hope that God continues to bless and protect you all.
Likewise. Likewise, thank you.
Thank you. So I'm this past month I've been a full course member, and as of last week have become a private client. I have not met with a representative yet, though. So my question here is that I was able to get 3 copies of my birth certificate from the state of New York. And unbeknownst to me, I found out that my last name is spelled starting with an S instead of a Z on my birth certificate. I know that a name change, I've read the book and watched most of the course and videos. A name change does have to occur to entitled nobility. But would I need to correct my birth certificate before we proceed with everything?
Not necessarily. How is it spelled on the actual Social Security card and driver's license?
As you see it on the screen.
Okay, cool. So all you got to do is take the name that you normally function with. You will list that on your DBA affidavit. That's what we're going to do for you. So it'll be the name of your express trust, doing business as the name on your social and driver's license. And then it's also going to be doing business as the name, how it's spelled on the birth certificate. And then we have to take it a step further. We have your name as you have it in the public, doing business as the name that's on the birth certificate. So we cover every aspect. If you go into court, whichever way they list you on the docket, you're covered under the trust. The reason why I have it done that way is because when you get to the point where it's time to do your name change, you don't have to provide your birth certificate to do that. They're just going to ask for a copy of the license, whichever way it is spelled on the license. And when they change it, you're not going to do what most people did in the past, where they went back to vital statistics and corrected the new name on the birth certificate and then put the new name on the Social Security card. We're not doing any of that. You're just going to take the new name and you'll place it on your updated passport application. So that will cover the names.
Great. And then so when it comes to authenticating the birth certificates, right, you said that you can get up to 10 birth certificates. Would I just continue to get the birth certificates as they are?
As they are, correct.
So I can continue to request more birth certificates now?
Yep.
All right, great. Thank you so much, and I'm looking forward to this journey.
Yes, thank you as well. We have quite a few of you all who are converting over to private clients, so we have to do some internal reorganization to see who is going to take on who. But it's pretty busy, but we'll work it out and get you guys settled. So stay tuned, Kareem, so we'll have that conversation with you so you can have your initial Zoom call about the entire process. Let's go back. Go back to Ryan. I'm gonna select for you to unmute yourself, Ryan, and see if we can get back to your question, if you're there. No. Okay. So I'll try to answer your question as best as I can. What I gathered from your question, Ryan, did you use the right entity for your lease, the trust enterprise or the foreign express trust? I would say you want to use the actual trust enterprise because payments and all of that is going to be easily facilitated through the enterprise more so than the actual 98 number trust.
So I'm the tenant. I'm the one paying. I'm not the one receiving. But I do understand what you're saying. My follow-up to that, though, is I think I'm going to be sued by a third party over this lease, not the landlord. And so if I am brought into civil or into district court, what happens then? Do I just rely on my my lien that I have against myself from the trust, or how do I even address the potential lawsuit?
So I think what I'm gonna have to do is schedule a call with you so I can get more of the inside scoop.
Okay.
I think the Foreign Express Trust and the Trust Enterprise is both involved, and so we want to make sure that the hierarchy is able to maintain itself throughout the case. So let me see here. I have some time tomorrow that I can give you a call. I'll email you and you can let me know what time is good for us to speak.
I can make anything work tomorrow, Avery, so just let me know what works and I'll be free.
Okay, good. All right, good. And I can also talk to you about the tax injunction stuff as well.
Great. I'll look forward to it.
All right, cool.
Thanks, Avery.
Likewise. Thank you.
Take care.
You too. Okay. Let's go back to Kim Wheeler. Are you still here? AW. Let's see. There you are. So I'm selecting for you to unmute.
I am here. Can you hear me?
Yes, there we go.
Oh, awesome. Thank you so much. My questions are about the 501c3 as well, and a question pertaining to the property tax. In addition to that, so we have multiple properties, and so I know that you were talking about putting everything in the 501c3, specifically in Delaware, then moving it to our state. Question is, if we have, say, a home and a second home, and then we have rental property, can they all be quote unquote literary property? And then how do you swing that with the IRS?
Yeah, all of your properties can be listed and taken into the title that way. What I was speaking of is, let's say these properties I know for sure is just going to be rented out forever. And maybe my family and I use one of them for a vacation. That's fine. I would have them in the trust name and the 501c3, which is based out of Delaware, to be listed as the trustee on that document. So I'm nowhere connected to it. No one in my family is connected to it. It's just managed by the charitable entity. That's basically it, how you're going to do that. As long as you know that you're going to start it that way and finish it that way, then do it that way. But if you for sure think that some of these properties are going to be sold, just put it into a land trust and leave it that way.
So if we have multiple, I guess, because I was thinking, okay, if you say religious purposes, if we have meetings in our home or second home of religious purpose, but that would make sense in a 501c3. But if we had another home that was a rental and we put it in the same 501c3, that would also have to be religious as well, right? Or we'd have to have a separate 501c3 if that one was literary.
Either way, literary or religious or charitable, the way that you prove to any government that you're actually going to use this property that way, you have to list to the public the service that you're going to provide. So if you're going to list it as a religious or whatever, you have to put it in the paper to show that on this date we will be having this event. Please come. If you're going to have a charity event listed in the paper, we're going to have a charity event on this day for this purpose. Please come. Literary. We just received this new affidavit from the trust. We're going to put it in the paper as the agent for this trust. And there's a stamp temp and there's a witness for it. That's how you show the governments that you're doing something for the public and you're not taking on, you're not inuring public benefit. So you have to do that. That's the only thing. You have to maintain records when you're doing things like that. Otherwise, they will challenge you and you could face a potential loss or cancellation of your tax status.
So if you put a rental house that's the investment property in a 501c3, I mean, what kind of, like, it's rented by renters, right? So how could that be used for a literary purpose if it's owned by the 501c3, or if multiple properties are in a 501c3 that are all rentals?
Mm-hmm. If they're all rentals, the tax entity is going to collect. So you have to tell your renters you need to pay over to this entity.
Okay.
So you're doing a work for the trust, and that can be considered a tax exempt work.
Got it. Okay, now that makes sense. Okay, perfect. And then we just made for a personal home, we just made a dispute for the property taxes. And we sent them the letter, sent them the first payment. It was like 10%. And funny, I got a call and they said, we received your letter and we received your money order with this writing at the bottom. So I'm just letting you know, we gave it over to our attorney. He read it. He said, go ahead and deposit it. But he wants to let you know that this is not payment in full, even though that's on your money order. So we're going to send you a statement saying what you owe left, but we're going to go ahead and deposit it. And I just told him, I said, just put it through the bank, send me a statement. So they're already disputing it, but I guess as long as they've already deposited that payment, I can make the next one, right? I don't have to wait 30 days.
Correct. And the only way that they can actually say that your money order is void is if they strike it out, make a copy of the striking, and then deposit it. And then also challenge your dispute with something of substantial evidence. If they haven't done that, that initial deposit stands as true in court, and you will be ready to sue them.
Okay, Gotcha. And then my last question, I'm still trying to hammer out the enterprise business checking account. I got with my rep, I guess the last time we talked was several weeks back, and they said they hadn't received instructions yet. So I guess I'm just kind of thinking that when I talked to the bank, they said they just need the certificate of trust and then the LLC paperwork, since the LLC will be the trustee. But I think I need to change my trust certificate to put the LLC in the trust certificate, I believe, to give to them on my enterprise trust certificate. And then that made me want to ask, who's the settlor and who's the trustee if I change that wording?
All you do is take the company and put them as the trustee in your trust certificate. That's all you do. The
so we still
remain the same, but I usually just have my foreign trustee as the settlor in the enterprise.
So I don't have that. I think because I think we signed up as a private client back in February. I think the only form I have is the one that was originally given to me for just generic personal banking. And it says that we are still the settlor. I don't have the other one where the trustee is the settlor. Back to me.
Okay. You have a choice. It's completely up to you. You can believe yourself or your husband as the settlor. But since you haven't opened the account just yet for this business, you can make that change and put the foreign trustee down as the settlor. Just go to the bank and ask them, are you dealing with a bank who's familiar with opening a trust account where an actual business is the trustee?
I've called 2 or 3 banks. I did talk to one that was familiar. They just rattled off. They're like, yep. All you need is the trust certificate. You need the trust doing business as the LLC, and then the actual state filing of the LLC paperwork.
State filing of the LLC paperwork. Okay. Sometimes they may also ask you for the state filing for the trust enterprise too, like they do in Ohio. But you will only know that once you walk in there and let them tell you. So I think that's the only hiccup that you might run into.
Okay, perfect. Thank you, sir. I appreciate you so much.
Oh, thank you. Thank you. I'm glad I can help. All right, let's go to Joseph. Joseph P. You are unmuted.
Hello, Avery. Thank you for all you and the team do for us. Greatly appreciated. First question for you is: I received a letter back from the I.R.S. off the correspondence letter. So they confirmed tax exempt status. When I was going through the call with the agent, she would not take a domestic mailing address or a U.S. mailing address for the trust. So my confirmation letter actually went to my trustee in Ukraine, and she scanned it and sent it over to me. I did in the I.R.S. correspondence letter request that the address be changed to a P.O. box that I have here, but obviously they didn't do it. Should I just respond again to the letter that they sent? There was like a little voucher that it says at the bottom, or is there another way to change that address that you know of?
Yeah, just do it all at once within your standard 9(8) correspondence letter, because your correspondence letter has to be sent to them to let them know that you are an entity that is non-tax and it doesn't have to file 1041s. So make your letter as if it's coming from your foreign trustee in Ukraine, and in the letter simply put details.
Sorry. Yeah, I did that already, and I got the letter back from the I.R.S. confirming tax exempt, but they sent it to Ukraine. They didn't make the change that I requested in the correspondence letter.
Most likely because this was an internal boo-boo on the I.R.S., whoever agent was speaking with you. And if I had been on the call and I heard this, then I would automatically know that in my 9(8) correspondence letter, I have to make sure it's in print. My letter is addressed coming from my foreign trustee with the Ukraine address as principal establishment for the trust. They would have to know that. The mailing address is held within the United States. I would put that delineation in the paperwork, but if you did that, you did everything correctly. Don't worry about it. As long as you have your 9(8)-6 or 7, you're good to go. The next time you'll be able to communicate with them in regards to that is if you're dealing with a tax issue, and you can update it there.
Okay. Yeah, I was thinking it might not be all that pressing. I shouldn't be expecting too much correspondence from them after this, right?
Right. It's really not that big of a deal.
Okay. One other question for you. In the last YouTube video that you posted, how the I.R.S. brought down the amount due substantially on I guess it was you personally. It was down to something like $30 or something. And you said you were leaning towards just sending in the payment to make it go away. I was, my initial take to that was, or question I suppose, is wouldn't that be admitting or contracting with the I.R.S. or giving them room to do something like that again in the future, or is there's something else that you were thinking just to make it go away?
No, because it's like if I have a $30,000 auto loan and I give them an amount under accord and satisfaction and they accept it and cancel the entire thing, there is no future contract to be done. It means I closed out a public contract. The initial contract that took place was, why did I get the $1,700 in the first place? Well, that's going all the way back to my working days when I was using the Social Security number. And that is an act of taking on the benefits and privileges of the United States. So that's a contract that I initiated into. So I had to close it. Now I used majority of the UCC 3 paperwork to bring it all the way down. I was hoping all the way to zero, which in my mind it should be, and in all of you guys, it should be zero. There's two ways to look at it. That $31 that they've assessed, it's really nothing. Because if you look down on that form, it said I had zero taxes, I had zero interest, I had zero principal. How can I have other fees if the initial foundation is zero?
Yeah, the whole thing made no sense.
Yeah. I think it was their tactic of showing you really don't owe anything, but we have to show this on the public record as $31 because there was no liability code to explain it. So with that being said, I could ignore it and not send anything. And I think I would still, if something was to come about it in the future, I can still handle it the same way that I know how. Or I can just give them $5 money order and say, this is according satisfaction to that $31 unknown interest, whatever you got it from. I don't have to give the full 31. I can give any amount. So, and that's what I did. I don't expect to hear from them ever again on that. So I closed out everything in the past that existed before my 2017 filing of this process that you all are doing.
So the mindset with that is the same as, well, it was basically accord and satisfaction. Nice. I gotcha. Okay.
And there was no bona fide dispute on it. You know, it was just
they did it.
They did it themselves. You know, let the UCC 3 paperwork speak for itself. So.
Got it. Could you speak a little bit on natural person? I know multiple times throughout the course, you mentioned you must do this as the trust or as the natural person. You know, in my notes, the main one that stood out to me was you must ask for the note. I believe it was for a mortgage, as the trust or the natural person. I know the trust is considered a natural person, and not that I'd want to do it any other way in particular, just trying to understand how it all works. Is it possible for us as a natural person to come in as a natural person?
It's a really good question, and that leads into a subject that I speak on all the time with Isaiah here. I've said before that this process, the things that you're doing, is backed up by biblical treaty. When we say the phrase natural person, the reason why each of us in here, there's 42 people in this call. Each of us are not natural persons alone. Solely, we're not natural persons. We have to come in at least 3 or more to be considered one whole natural body. A trust itself is a natural body because there's an arm, there's a head, there's a leg, there's a body, there's a heart, there's a brain. Just like in the word, in the Bible, it's going to say where 3 or more gathered together, there will I be. So if you're talking about a natural person and you're trying to invoke the power of the natural person, you're talking about invoking the power of God. And that is why all of your constitutions, when it talks about in the preamble, where it says we the people are a trust indenture, or we are a trust, a natural person putting together a trust indenture, and therefore God is speaking. That's how the government looks at it. We try to do things on a civil basis individually, and we don't get anywhere in the process until 3 or more come together in a trust and do the talking. That's all it is to a natural person. That's all it is. Donald Trump was trying to show that in his Resolution 48, House Resolution 48, February 22nd, I think it was 2019. And he tells you what a natural person can and cannot do, and all of the other entities outside of that are just artificial. So that's the overall basis behind natural person. You are invoking God in the midst of your situation. That's it.
That's why an individual living soul cannot ask for the note or pretty much any of the other things that the trust can do.
Correct.
I gotcha.
Because the individual person who's asking for the note is what? Is born in a copyrighted timeline past the 1500s. And that timeline is based upon Pope Gregory, and he's the one who initiated the Unum Sanctum Express Trust. So everybody who has a birth certificate using a surname, Sir is under serfdom, that's a name that's under their system. It's a franchise. So you're definitely not a natural person by yourself using that name. You got to use a name that is not connected to their system. And they see that person as God.
So even in the definitions, when it's saying a natural person could be an individual, it's not going to stand.
It's not going to stand.
I got you.
But I do know that in their definitions, when they talk about the definition of a trust, and they say that that trust is an individual, and then break down that the natural person. Well, one thing that they left out is that a domestic trust or a foreign trust? When you look at those two contrasts, now you're talking about a natural person, and you're still talking about an individual that's under the corporate charter of the United States.
So domestic trust isn't a natural person?
Correct.
Interesting. Wow.
It's a fiduciary working on behalf. Hopefully, if it's set up right.
Right. I got you. Okay. Thank you very much. Appreciate it.
You're welcome. Good questions. So I think we have 2 more that haven't had their hand raised. So let's see. We're going to Rex B.
Hey, Avery.
Hey there, man. How you doing?
I'm doing well. How are you doing, sir?
Doing all right.
So I am still waiting on my initial CP 575 letter from the I.R.S. So pretty much waiting on that stub so I can send to them with the correspondence letter. I've already sent them 3 correspondence letters. Is it okay that I don't get that CP 757 stub and just keep sending the letters?
Are you talking about your estate?
Sorry. For the 98 number.
Oh, okay. Yeah, it's okay if you don't get it. You still got to send out the correspondence letter anyway, as if you did get it.
Okay.
But you will at some point. You'll get it.
Okay. And then another question was just regarding the international driver's license on the sophomore course. It said to use expatworld.net, but it doesn't have that feature to apply. Is there something else that I'm missing?
If you want to get the license, I'm not using, but the only avenue I can give you, just send me your email and I will email them to contact you.
Okay.
You can follow through with their procedure, and that's just to get the actual driver's license out of Panama. And then the next step is to get the IDP. And I recommend you get that out of PATA.
PATA?
PATA.
Oh, PATA, PATA.
Yeah. They're based out of Hawaii, and they will get you any international driving permit for any country.
Okay.
So
just gotta
on there.
Okay, just gotta look them up.
Yeah, just PATA.
Okay. All right, cool. I'll send you that email.
All right, cool. Thank you.
Thanks, Avery.
All right. Who is the Zoom user? I believe that's Katrina. Go ahead, unmute your mic.
Hi, can you hear me?
Yes. Glad to finally connect with you.
Yes. So I went to file the copyright in Seminole County, and they told me to go online.
With Seminole County?
Yes.
What did you submit?
The copyright.
The copyright. So you have already recorded your copyright with the Copyright Depot?
Yes.
Okay. So all you have to do from there, just take the Copyright Depot number and you can list it inside of the actual the summary, your summary minutes. You should be familiar with the summary minutes, which is like the third page to the Declaration of Trust.
Yes, I did that.
Okay, all right. You may have to turn your speaker. If you have two speakers, turn one of them down.
Yes, I just turned it off.
Okay. Now, to record in Seminole County, the best way to do it, and it really is the rule of thumb for any county, first get your trust bond. Get that first. You're going to record your trust bond and have your Declaration of Trust right behind it with the summary minutes, ending with its proof of service. And of course, include trustee minutes for the affidavit of domicile and the trustee minutes for your fictitious business name statement. Those are the two things that I really, really want to be recorded. If you can, get your promissory note in there too.
Okay.
That's your packet that needs to be mailed to Seminole County, and you have to give them a cover letter saying exactly what you want them to do. Please record this in the bond section. That's all I want you to send for your first wave. Once it's successful, your second wave would be filing the initial non-UCC, and you're going to send that by itself. Nothing with it, by itself.
Okay.
Okay. When you have that done, then you can do the UCC 1. If you're going to do the UCC 1 in Florida, you go to floridaregistry.org, and that's all done online. Just one filing. Then it is the UCC 3. So go to the junior course, look at version 2, UCC 3. You'll see exactly how to do that. Now that's just a repeat of how you did the initial non-UCC in Seminole County.
Okay.
And it should be done.
Thank you. Okay.
Okay.
Great.
Right. Sounds good.
Yeah, that's good.
All right, good. Hope you all got that. No problem. Yeah, no matter where you are in this union, You could do it in Seminole County. They've been pretty good with us. If you're having trouble doing it in your home county or your home state, do it there. And once it's done in Seminole County, let's say you live in Virginia, just simply file a UCC 1 in Virginia to connect it all. If you're in Nebraska, file a UCC 1 in Nebraska to connect it. Any state, that's how you do it. Where do we start with the process for the DMV? Says Katie Hobbins. The process for the DMV. All right, so step one, you know to do your injunction. Isaiah and I are going to be doing an update on the injunction process. So you do have the videos in the course to see how we used to do it. It's kind of the same process, but I have my little flares and tweaks based on how they have been responding to all of you. We'll be showing that along with the certificate of trust, how to do that at the DMV pretty soon. But if you're talking about a driver's license with the DMV, there's a way around that too. I just can't show you that until my passport process has come back from the Department of State. They're actually taking a long time with that. I paid for the expedite service and it says it's supposed to be 2 weeks, and now they're talking about 7 to 9 weeks. I think that's across the board for everybody. In my personal opinion, why are they doing that? If something goes down and you're trying to get out of the country, you can't leave. I think that's why they do that. That's just my opinion. But yeah, all that stuff with the DMV is coming. Like I said, I just got to have the passport stuff done first, so I can update you on how to do that with the court. And then you can do the actual DMV update, because most people don't want to have a foreign driver's license with an international driving permit. They want to be able to give the officer an actual document that they're used to seeing, and it still doesn't connect them to the United States. So that's a win-win either way. I'm going to go to Don Trail. Don Trail, you are unmuted. Just got to unmute your mic.
Hello.
There you go. Hello.
Yes. Hey, nice to meet you, sir.
Good. Did I pronounce your name the right way?
It's Dan Trail, but Don Trail sounds better. So
okay.
My middle name. Anyway, I've started the course, and I think I'm in the freshman 2.0 or 3.0 or something like that. Well, before I signed up for you, I was signed up for someone else. You're not gonna like this, but I was signed up to be a secured party creditor. But I understand that you and him were both right. I think just the phrase secured party creditor has thrown everyone left field. Right. But anyway, I filed what some people are calling a W-4 sandwich. And I'm not even sure if I was supposed to do that, but I filed that and I sent it out to the I.R.S. And I've also did what people call an endorsement on a voucher that I got from a creditor from a light company, and I endorsed it and I sent it off to the Criminal Investigation Division of the I.R.S. because that's what those are the instructions it was telling me to do. Mm-hmm. And I'm pretty sure, based off your findings, I don't think I did it correct, but I haven't got to that part in the teaching yet. So, have I done it correct? Am I in trouble? What do I need to do at this point?
I've never done that process before. You said the W-4 sandwich. I've never done that process.
It's basically you get a W-4 form and you whoever you give your social to, you're an employee of them. That's my understanding. And I did it was basically an audit on a bank account to see if they did any they call them TTNL transactions, basically transactions on the private side and whatever like that. And, if they have, then the IRS is supposed to audit them. Well, they're going to audit them, and then they're going to investigate to see if they did any private transactions on my behalf without my knowing.
Mm-hmm. Mm-hmm.
Does that sound?
On your behalf without your knowing. Put it this way. They're gonna see it as you did know. Like there's a statute and code that they go off of when it comes to the dollar bills, the Federal Reserve notes. If you use this dollar bill in any transaction, they claim you to be proficient in the use of that dollar bill, despite you not knowing how they're going to use it after you give it to them. So they'll tell you that you can't sue them for how they use that negotiable instrument because you're supposed to know how negotiable instruments work. If you didn't want us to use it, then you would have given us a non-negotiable instrument and you would have properly secured that non-negotiable instrument within the trust before you gave it to them, right? So they're going to, just like that, they're seeing it the very same way with your social security number. Remember, your social security number is backed up by bonds that solidify the quadrillion-dollar lien that's on everybody. So for you to do this process, I think you can continue doing it if you want to see where the road goes, but an asset to that process would be the UCC3, hands down. You must remove that agriculture lien off of your person so that the natural person, the trust, can speak freely and question the validity of the debt. And the validity of the debt is also asking the question, why did you guys do this under my name without even getting permission from the trust? You didn't even reach out to see if I was in a trust. They're not going to do it until they know the whereabouts of the trust having the subject, which is the title, that's the birth certificate. And they're not going to do it without the matter, the subject matter jurisdiction, which is that afterbirth DNA material that they have locked up on the holy seas. Until you've done that, I don't think you're gonna get far with the process. I don't know if you've heard anybody have success with it. I've never heard of it.
No, I haven't.
Never heard of it. But you can try. You may uncover something that could lead to something else for all of us to learn from.
Okay.
Yeah. I'm going to shun down anybody's process. Everybody needs to go through it and find, excuse me, and find what works and what doesn't work.
Okay. Also, I filed a UC. I've got my birth certificate authenticated on the state and federal level, and I also have a copy of my vital records birth certificate, the long form. Now, I sent off a UCC1, but when I got it back, I sent it certified mail and I got my green card back. But when I got back the actual results of my UCC1, the letter looked like someone had opened it and tried to close it again. And the letter in there, I can't even remember what it had up there because I moved from the place, but it was like a blank piece of paper. So in my mind, I was thinking, oh, they know what I'm trying to do. So they probably had one of their agents, intercept my mail and do something, but I don't know what happened. So how many UCC1s can I file? And do you have a video online on how to file it properly?
Yeah, we got a video online for it. There's unlimited UCC1 usage. Really, a UCC1 is perfecting and telling the public of the original lien. Your original lien is recorded by way of checking off that small little box on the financing statement called non-UCC. So if that process wasn't done first, really the UCC1 is they're just taking your fees and it's not really doing anything. So it must perfect a non-UCC first. So you may want to go back and see if that's been done. But to answer your question, UCC1s can be filed. There is no limit to those. I mean, I believe in some states they go all the way up to 10 years before you renew them.
Mhm.
And it's really just to put on there what is the property of the secured party. That's it. Who is the debtor to it? Who owes who? That's all you're saying. In
And
this process, we have the 14, what is that, you guys? 14 billion or 9 billion? $9 billion lien that the trust puts on the actual ens legis. And we record that on the promissory note, which is attached in the collateral to the non-UCC. So that really puts you in a position where no other entity can tell the trust what to do with that name. Yeah.
Okay, great. And far as my I was looking for the word, but it was a remittance. I sent a remittance coupon to the CID division of the I.R.S. to get them to set off or discharge my the debt that I've accumulated with the electrical company. Did I do that right, or are y'all not even? Because I haven't heard you talk much about remittance. So do y'all not do that since you are teaching us about the trust and how to operate inside the trust? Doesn't even matter none now, or what?
I don't teach that because
Okay.
I've never used it and I've never seen any laws that said we could do that.
Okay.
Yeah. We got a couple more minutes. I got to get to two other people before everybody else, before we end the call today. We got two more people.
All right. Thank you, sir.
I appreciate you. Thank you. Going to Robert. You are muted.
Good day to you, sir. How are you?
Good day. The day is going well. Thank you very much. How are you?
Yes, sir. I'm great. I'm glad to hear your voice. I just had a question about the accord and satisfaction and the bona fide dispute. You know how you send in your bona fide dispute first. That's the most important thing to send in. But if it's too close to your due date, let's just take an example of a credit card. If it's too close to the due date and you have to pay that first, so you send in your bona fide dispute, and then let's just say your due date is the following week. Are we okay to send in a regular electronic payment and then send in like a check with the restrictive endorsement the following month?
Yes, because unless I think the earliest that you can send off a letter to anybody by using next day delivery, let's say you use next day delivery for the bona fide dispute, it gets there the next day, and then you give them 3 days to go ahead and make their decisions and their findings. Most likely they're not going to use next day delivery to get back to you. So all in all, the maximum realistically in that bona fide dispute is 5 days, to be honest. It's 5 days. So if you can send it off next day delivery and wait 5 days and send them the payment, because then again, that payment has to be next day delivery as well. So yes, if you can't do that, go ahead and make a regular payment electronically, followed by another payment via money order, so you can write accord and satisfaction on it.
Right, as long as the most important document, which is that bona fide dispute, is in there before all those accord and satisfactions, money orders or checks start coming in.
That is correct.
Okay. Just an update, we officially have 2 trusts recorded in the county in my house. So next is the marriage contract, and then that legal divorce, and then we're off to ask you for help with the marriage contract after that.
Ooh, you were off to the races. You're moving very quickly in the process. Very good. Very good.
It's all about the execution.
That's all it is. You execute properly, you can receive exactly what you're looking for. When we do this divorce process, When it's completely done, what I want you to do is go back to the county courthouse and redact that information from the public view. That's just a step that we're going to have to do.
Okay.
But we can't do annulments. There's some cases that we can, but most likely a long, successful marriage, we can't do that. So, yeah, redacted information will help with that marriage trust, putting that together and getting that recorded for you. Awesome.
Perfect. And then we have two name changes pending as we speak as well. We're going back to the county in front of a judge next month, I believe, to officially have our names accepted as far as the change goes.
Great. That's a pretty easy process. It was pretty easy for me.
Yeah. They just it's pretty unless they find something on the back end that gives them cause to not accept it. It's usually pretty smooth, right?
Yeah, on the back end, like something with the Office of Management and Budget. If they find something there that's over $2,500 in tax, or with the state, then they may say, let's go ahead and resolve that first before we do this case. If it's astronomical, then we got to do an entirely different approach, to get that discharged. But I think most of you will be okay with that process.
Awesome. Yeah, we shouldn't have any issues. And then wait to file for my passport application with the explanatory statement after that, right?
Yes. After that, I am looking at my status of my passport application online right now. And like I said, it doesn't matter which service you pay for, they're still only going to give it to you 7 to 9 weeks. So I wouldn't even recommend paying for expedited. It's just going to be bad up until the end of the year. Yeah.
Oh, wow. Okay.
But you'll get it.
Okay, good to know. One last thing before I go. If you find some time to update that land trust document that we were talking about last time. I have my rental property that I'm planning on putting in a land trust in I think month 5 it is for the accordant satisfaction. So I'm ready to pull that trigger when I can find a land trust document that's reputable. And of course, I wouldn't settle for anything less than what you have.
Yes. Okay. No problem. You're ready to move forward. So yeah, I'll put it's really just a template that I would use for a lot of lease options. So if you want to use that land trust template, so that way you can merge it with your trust enterprise to take title to the property, to sign off as the trustee, or if you have a business, that will fit perfectly as well.
Okay, perfect.
Okay.
Thank you, Avery, for all you do. Appreciate you, sir.
Appreciate you as well. Thank you for moving through the course quickly and swiftly, and taking the time to really soak it all in. That's very impressive. Very impressive, showing that it can be done.
Yes, sir. Thank you.
Thank you. Okay, everybody, we got time for one more. I'm officially clicking on Shubi Yayu before 6 p.m. and that will be it for today. Go ahead. Shubi Yayu.
You hear me?
Just a little. You gotta turn your volume up. It will be okay.
Okay, can you hear me?
Yeah, go ahead.
Okay. I have 2 questions, but the first one is about the last time we was on here, you was talking about the bill of attainder rather, and so I sent that off, and I was just wondering, I got 2 letters from the mortgage companies about they will respond to the letter, but if I have to go to sue, what will be the papers I need to file?
If you have to sue, what would be the documents to start your lawsuit?
Correct.
an initial complaint is the very first thing you do. Now, every courthouse has their own packet as to what they need to begin an actual lawsuit. What is the damages? How much?
I'm going for double the amount of the loan.
Good. So they may take you into federal court because of the amount. They might do that. So you got to first start at the state level. Let them make that decision to do that, but it's going to take an initial bill of complaint. But just go down to your courthouse and find out exactly what are the forms you need to fill out to file a lawsuit. You don't have to tell them who it's against. They'll just say, look, you just have an attorney draw up the initial complaint. If you hear those words, then you just go directly into the course and purchase, or I'm sorry, you go into the member documents and put in your application for the bill of complaint. And we'll get over to you that webinar with the template so you can fill it out and watch it together on how to put that together.
Okay.
Yeah.
I did go to the courthouse. They gave me paperwork. They said it's going to be about $170 to file the paperwork because it's over. I think it's $5,000. It's over that, and it's a different filing. And I did look at it, and I haven't really started anything, but it's a certain way you have to fill out the paperwork. They have to have it's a form saying that you have to have I can't think of it right now.
Yeah, everybody's a little bit different. It'll come to you, but it's probably going to come to you after the call. It's okay. It's all right. Sometimes you can get examples of how to do it in your courthouse too.
Okay. So I'll look at that even further and then see. I'm giving them a little time to respond back since they sent the letter saying they're going to respond.
Yeah. Keep this in mind. The plaintiff is the name that is contracted with the bank. We've learned that.
Okay.
When I did lawsuits for lenders, I'd say 2 years ago, I can put the trust as the plaintiff. But too many of those filings, now they're like, nope, we're gonna not even hear your case because the wrong party is attached. So just put your name that's contracted with the bank as the plaintiff, and then put the bank and all of its officers, all of its registered agents down below as the defendants. Number one thing that we need to do, because I don't want you to file a case, pay the fees, and then we got to get it dismissed off of something that could have been avoided.
Gotcha.
So, yeah.
Okay. Now, the other question was what you was talking about with the UCC one. I found in the state of Maryland, you have to do it online, and you can upload all the documents with that UCC. You just have to pay extra for all the documents that you upload. But you can upload your promissory note, everything at that time, and it'll come back for the certification of it.
That's great. If you find an easy way to do it, please take the easy route.
So if anybody in the state of Maryland, that's the best way to do it. Just upload all your documents with your UCC one, and they'll certify and send it back with another letter saying it's good.
Awesome. Thank you for that plug. Thank you.
All right. Thank you for everything you do too, Avery. I appreciate it.
Oh, no problem, you guys. No problem. Let's see. Just reading the notes to see if I can address one last thing. Let's see. I'll have to address that a little bit later. Okay. So that's it, you guys. Thank you all for coming in. A good 2 hours full of good questions. I hope you all got something out of it. I know I did, learning a little bit more about where you guys are in the process. Those of you that have converted over to private client, let us go through the applications and start doing an assignment. So that way we can set up your initial call and get you going. Because there are going to be some things that we need from you guys to do, and the rest of it we do. But we're going to put you on schedule so that way we can keep you up to date as to what is happening with your packet. With that being said, I'll see you guys on the next first Saturday of September. Peace out, you guys. Take care.